with a 10 o'clock docket. Mr. Kenny, we're going to start with your cases to get you out of here. First of those is Dylan Phelps. Mr. Phelps, I can see you over at the jail. Can you hear me? Yes, I can, Your Honor. All right, so Mr. Phelps appears via WebEx. Mr. Kenny, his attorney, Mr. Lindsay, is prosecutor up here in the courtroom.
Okay, you guys, welcome back. We are about to listen to Barry Morphew's discovery hearing. Right now they're taking care of another case first. So I'm going to see if I can't get video as well. So I'm going to try that right now. But you guys can listen to this case while I'm doing this. So we don't miss anything.
You commit second-degree burglary. Class 5 felony. The sentence would be open to the court, but would not exceed 4 years in the Department of Corrections. In other words, the sentence is anything from probation up to DOC. Case 21M105 would be dismissed. Is that your understanding of the agreement? Yes, it is, Your Honor. Did you sign this document, Mr. Phelps? Yes, I did. Your signature indicates to me that you've read the document and that you understand it. Is that true? Yes, Your Honor. Do you have any issues reading, writing, or understanding English? No. Are you satisfied with Mr. Kenny's work and advice on your case? Yes, I am. Are you under the influence of any substance right now? You're thinking? No, Your Honor.
You understand you do not have to accept this agreement, and instead you could insist on your right to have a trial.
Yes. That trial could be to a judge or to a jury, your choice. It would also be your choice whether you testified at that trial. And if you did not testify, I would specifically instruct the jury not to hold that against you. You'd be represented by counsel, I assume Mr. Kenny at that trial, and you'd have a right to have that trial within 6 months of your request. At that trial, you could question whatever witnesses are called by the prosecutor, and you could call witnesses by subpoena if necessary in your own defense. You'd be presumed innocent, and it would be the burden of the prosecutor to prove the charges beyond a reasonable doubt before you could be convicted. You could also appeal the outcome of the trial if you did not agree with it. You understand that by entering into this plea agreement, you give up your right to have a trial, and therefore you give up these rights that are specific to having a trial. Yes, Your Honor. Mr. Phelps, do you understand what attempted second-degree burglary means? Yes. Do you have any questions about the sentencing parameters? No. Has anybody made you promises that are not included in this plea agreement? No. Do you understand once I accept the agreement, you cannot later change your mind? Yes. When you enter your plea, will that be a voluntary act? Yes.
Mr. Kenny, I do have an affidavit in my file. Is that sufficient for the factual basis?
It is.
Mr. Phelps, do you have questions for me or for Mr. Kenny before I ask for your plea?
No, I do not, Your Honor.
How do you plead then to count number 5, which is the class 5 felony of attempted second-degree burglary?
Guilty.
All right, the court accepts your plea. I find that you've been represented by a competent attorney. You understand the nature of the charge to which you're pleading. You understand the plea agreement and its consequences. Your plea is voluntary and knowing. You're not under the influence. There's a factual basis for your plea. You understand you have a right to have a jury trial, and you're giving up that right. Mr. Kenny, Mr. Lindsay, because there's a pretty wide sentencing range here, I don't think I need a pre-sentence report. I know Mr. Phelps pretty well, but maybe a risk assessment might be a good idea.
That's fine. Do we need a pre-sentence report for a ComCore screen?
Yes. Are you asking for ComCore to be a possibility?
Asking for it to be a possibility.
Okay.
I think it makes sense.
You can ask for a pre-sentence report. You have that right.
Why don't we do one? I think it makes sense. We're still going to be asking for probation, but I like all options on the table.
Understood. Okay, Mr. Phelps, I'm going to order a community corrections screen as well as a pre-sentence report. Those take some time to accomplish, usually between 6 and 8 weeks. So we'll get you a sentencing date in late September. Mr. Canny, all of these dates will be subject to the trial that's set during that time not occurring.
Understood.
Late September is trial after trial for me. We could set him on the October 6th regular PD docket.
Yeah, I'm wide open then.
Fine with people.
All right, let's do that maybe later in the day in case the hearing takes some time. Mr. Phelps, why don't we set sentencing for you at 4 o'clock, October 6th? And you'll be here in person for that.
Okay.
Okay, so expect the probation officer to come over and visit with you, and we will see you for sentencing October 6th.
Thank you, Your Honor.
All right, thank you. Okay, and then the next case or cases involve Mr. Mullins, 20 CR
Wait,
121.
what is he
20 CR
wearing?
68. Mr.
What?
Mullins appears with his attorney, Mr. Canny, in the courtroom. Mr. Lindsay's in the
Oh.
courtroom. We have Mr. Torres by WebEx. Mr. Canny.
Judge, without going into great detail, Mr. Mullins is doing much better. We think things are back on track.
My bad. I thought that was Barry.
I'd ask to set this over maybe another week or two till later next week or early the week of August 2nd or 3rd, or possibly the following week.
I have a docket August 4th. Are you available?
That's the price. Start a 3-day trial in Canyon. It's a very likely go that day.
Starting that day.
Yeah.
Would you have trial or would you have time the morning of August 3rd?
Wide open.
I've got you here for pre-trial cutoff at 8:30, Mr. Lindsay.
That's fine, Judge.
8:30 on the 3rd.
It's great.
Mr. Torres, do you need Mr. Mullins to do anything for you? I'm sorry, you're muted. Let me unmute you.
Just have you sit back. Well, you want to move the chairs around?
This will probably be fine.
Oh my gosh, Scott Reich in the house. Everybody say hi to Scott. Thanks for stopping in. I totally thought that was Barry in street clothes. I was like, what is he wearing? But hey, if you guys aren't familiar with Scott, which I'm sure you are, but if you're not, make sure you click on his name and head over to his channel. Look at this guy. He's really pleading his case. Let's take a listen. Thanks again, Scott, for stopping in.
Yeah, we'll see you back here on the 3rd.
Thank you,
Okay.
Judge.
Thank you, Mr. Torres. Ms. Nielsen, I've unmuted your microphone. Can you hear me?
All right, you guys, I just took slow mode off. It must be on automatic slow mode. So I went ahead and removed that. So you shouldn't have any delay in chatting. I apologize.
Microphone, can you hear me?
I can.
Okay. And let me just do the same for the detention facility. Okay, Mr. Morphew, are you able to hear me?
Yes.
Okay. Let's call Mr. Morphew's cases 21 CR 85, 21 CR 78. Mr. Morphew appears via WebEx from the jail, audio only. His attorneys, Ms. Nielsen, Ms. Eaton, appear via WebEx. Mr. Lindsay's in the courtroom. Ms. Eaton, Ms. Nielsen, what I'm going to do is mute the microphone over at the jail. You can hear I get a lot of feedback from that microphone. I've instructed the deputy that if Mr. Morphew needs to say something, that the deputy will unmute or let me know and I'll unmute, and then you can address Mr. Morphew.
Thank you.
Judge, Mr. Pembleton is also here for the people.
I'm sorry, Mr. Pendleton. I've gotten so used to it just being Mr. Lindsay.
I understand.
Okay.
Maybe this here, just so we can on this. I want her to hear if she's here with Barry. Yes.
Miss Eaton, I can hear you.
Sorry.
I know that's okay. I'm just letting you know.
Okay, let me mute myself.
Well, yeah. Okay, we're primarily here on case 21 CR 78. In that case, a number of motions have been filed by the defense, all relating to discovery. There was a motion for discovery and sanctions filed June 24th. A request for a contempt citation also related to discovery issues July 6th. People filed a response to the motion also on July 6th. And then on July 8th, I'm sorry, there was a reply to the response filed July 7th. And then on July 8th, the defense filed another motion requesting a hearing and for sanctions. I've reviewed all of the motions, the responses, the reply. Ms. Nielsen, Ms. Eaton, because I have this on hard mute because of the number of people on the call, I don't think you're able to unmute yourself. So if you mute yourself, I have to go back each time and unmute you. Maybe I can figure out a way, not today, where you can do it on your own. But right now, I don't know how to do that. So both of you,
Shell, make this lady a sign that says unmute, please.
Unmuted.
okay. Then I will mute Ms. Nielsen. There we go. Okay, to summarize the motions that have been filed, the original motion on the 24th of June correctly recites that on the 27th of May, we were here in court. I issued an order regarding discovery. Discovery was to be produced by June the 2nd. On June the 2nd, a terabyte of information was discovered to the defense via a hard drive. The defense is alleging that some of the files in that terabyte were inoperable. The defense highlights that they did not receive the forensic image of Mr. Morphew's phone or some of the recordings from a spy pen. And also that they did not receive Suzanne Morphew's an image of her iCloud account. And the motion for a contempt citation was similar allegations. The people responded July 6th, essentially saying that they did provide a terabyte of information, that's a very large amount of information, and that at the time it was all of the discovery that they had on hand. They indicated some law enforcement agencies had not compiled the discovery yet in a central location. They highlighted the number of agencies involved in the case and the difficulty of getting all that discovery in one spot. They alleged that since the original motion was filed, discovery has been provided through the state e-discovery system. That they had delivered the mirror image of Mr. Morphew's phone, Mallory Morphew's phone, and Macy Morphew's phone to the defense on July 6th. They alleged that the delay was because the agency that originally had the phone and created the mirror image, when they did their search pursuant to the search warrant, it altered the mirror image. And so what they had to do was recreate another mirror image of the phone to get to the defense that the prosecution made a special request to get that done sooner rather than later. And then in the last motion filed by the defense, July 8th, they say that I'm sorry, I need to add one more thing. In the response, the prosecution says that, or said that the items that the defense didn't have or couldn't access have either been provided through action discovery. And I guess I need to know what that means. Or that those files could be read, but only after the defense downloaded a reader file, and that was provided by the DA. What does action discovery mean?
Judge, that is our system that we're in, and that's the one that we use for e-discovery. So once it goes in there, the defense gets a notice that it's ready to be downloaded, and they can download those items.
Okay, so just so I understand, that big cache at the beginning was on a hard drive. And since then, it's been through what I would call the regular discovery system.
Some of it has, some of the ongoing discovery has been by additional hard drives or CDs as well, but the ones that are identified in that response were done through the e-discovery.
Is e-discovery the same as action discovery?
Yes.
Okay. Okay, and then, I'm sorry, in the last motion filed by the defense on July 8th, they alleged that the hard drive provided with the mirror image of the phones is not functional, and they included an affidavit from their expert. Did I get that about right, Ms. Eaton?
Your Honor, I think nearly there. On July 7th, we filed a reply to their response, and in there we included additional items of discovery that also have not been provided. The court can look at paragraph 7.
So that indicates information from an HP laptop, an Amazon Kindle, and an Apple laptop.
That's right.
Okay. So I think the defense has laid out their request and their facts pretty clearly. Is there anything additional that the people want to add to the record?
We do, Judge. As indicated in the reply, those 510 recordings, those were all in the way that we received them, as well as the way that the agencies downloaded them. Some of those recordings could not be opened because they showed that there were files, but there were 0 bits with them. So when you went into the hard drive and you looked at the size of those files, they were zero bits. Additionally, in that same overarching file, there was an Excel spreadsheet that indicated the same. That was from the agency. Additionally, we did provide another copy of that spy pen when they requested it. As far as the phones, we gave them that first hard drive with the first hard drive with the phones that they say was inoperable. We subsequently provided a second copy of those phones. Additionally, we provided the iCloud account. As far as the items in paragraph 7 of their reply brief, I believe that they're asking for the master forensic copy of those items. They have working copies that are tailored to the specifications of the search warrant that were given on at the same time as the hard drive, I believe it was, or the next day. And I believe what they're asking for is the master copy that has all the data that is inside and outside the parameters of the search warrant. And we have that, but as it is not evidence and it has stuff that we cannot look at, it is not discovered. It actually came to us with a big sticker on it that says "Do not discover," because it is outside the parameters of the search warrant.
There's something on my desk.
So Judge, just a little further on that master archive copy, that is a complete copy of those hard drives. But then they go through that and do the search based on that so that they're not changing the hard drive of the actual computer. They take that image of the hard drive and then they do their search warrant off that master archive copy. And that's tailored to that search warrant. So that's why there's a master archive copy as well as working copies that are within the parameters of the search warrant and only things that we can look at. And so if they are asking for those master archive copies, we would ask to deny that because they are outside the parameters of the search warrant. And if the defense gets that, the people would be entitled to that as well. And I think that would be contrary to that search.
Okay, focusing just for a moment on the items listed in paragraph 7. Do we know who owns or who owns the HP laptop? Whose is it?
I don't know off the top of my head. It came out of the residence. All three of those came out of the residence. But we do not know who the owner is off the top of my head.
So the HP laptop, the Amazon Kindle, and the Apple laptop all came out of the Morphew residence?
Correct.
Okay, Ms. Eaton, Mr. Pembleton just indicated that a second copy of the mirror image of the phones was provided. You didn't say the date. You know when?
I don't have the date off.
I do.
When was that, Ms. Eaton?
July 19th, 3 days ago.
And Judge, with that, I want to explain that process. We don't have that. We have to request that from the agency that's up in Denver. They have to download that, go get that, bring it back, and then give it over to defense.
That's the same process that was laid out in your response.
Yes, Judge.
They had to do that again?
Yes. Because they didn't make extra copies of it for the defense. They just made one copy of it for them. They indicated that it was inoperable, so they didn't have to re-image, but they had to download it or copy it over to the hard drive again.
Okay.
So Rocky Mountain Forensic Center did it the first time. I think the FBI did it the second time.
And do we know, Ms. Eaton, what the issue was? Your expert said he could get about 70% of it copied and then he'd get an error message.
Yeah, no, we don't know, but that's something that their expert could have identified when it was downloaded the first time. You look at how many files and or data there is in the original, and then when you copy it, you make sure that there's the identical number of files or data before you release it. That's this pretty simple way to ensure that there's no corrupt files or that all the files are on there. But in addition to that, the file that they provided to us, the hard drive they provided to us, on July 6th didn't include the reader, which is the most important part, the Celebrate reader, which is the most important part of the forensic investigation when you're looking at phones. And so that was actually just provided on July 19th after we requested it again. And that drive is proving to be operable, and all the files are there.
So was your expert not able to copy it because you didn't have this reader?
No, we didn't. The reader we would have needed regardless. But our expert, as he described in his affidavit and showed pictures, it just kept coming up to an error message and it was corrupt. And so we weren't able to know whether we had all the files and what files we did not have. We were unable to make that determination.
And do we know whether that error message is because of the data or because of the method that was being used or the mechanism or machinery being used by your expert, Ms. Eaton?
Our expert contends in his affidavit that it's a result of the way that the files were copied and not like an operator problem. The expert attempted to try using 3 different computers and 3 different sources and described the lengths in which he attempted to operate the drive and was unable to. And so the files that were on the drive, they were not operable, and so caused us to have a hard drive where we were unable to ascertain if we had everything, what we were missing, because we were missing documents and files. But that was not on our end. That was absolutely on the end of the prosecution and their expert. And that could have been absolutely dealt with at the time it was copied by doing a double check. But again, regardless, at that time, the reader was not part of that drive, the inoperable drive.
Any response, Mr. Pemberton?
Judge, one, the drive was obviously operable because they were able to get into the drive and find out what was in it. They said that they didn't find a reader. Obviously, they could get into that drive and look at it. What the expert couldn't do was copy it. And that's what they were having problems with, not necessarily that they couldn't open up what was on the drive. Additionally, we don't know where this error came from. It could have been in transport at any point. These are hard drives. I believe it is a disk hard drive, not a solid state hard drive, which there is a difference. The disk hard drives, they're not as stable. They have moving parts as opposed to the solid state hard drives like your flash drives that don't have those moving parts. And so it could have happened at some point during that transport. We don't know. Neither does defense. So once we were informed of the issues with the hard drive, we took steps to remedy those immediately. So that's where we're at, Judge. And it's an ongoing thing. As indicated, there are terabytes worth of data. And so this discovery process is ongoing, not only when defense tells us that, hey, we think we're missing something, but also when we're going through discovery, if we believe that we're missing something, we're going through and trying to identify anything and get those items that might have been inadvertently left off, as well as continuing to disclose that ongoing discovery.
Okay. In the original discovery motion, it lists several files that could not be opened, and in the response, the response seems to indicate that if they couldn't be opened originally through the hard drive that was provided on the second, that they were provided through action discovery, or that a downloadable reader was provided to defense in order to read those files. Is that the status on the files, Ms. Eaton?
Your Honor, I want to go, I want to go back to the issue of this hard drive and just note that, you know, I kind of have, okay, well, let me go back to the hard drive. The hard drive should have been produced on June 2nd. It was, the information contained on it was used in drafting the affidavit, and it was used for the prior year where the court had signed an affidavit, a search warrant to allow them to access those phones. So that has been in the possession and utilized heavily by the prosecution for a year. There's no reason why we needed to file these motions and to make these requests repeatedly until we finally received an operable and fully functional drive 3 days ago. As far as the items, you know, I want to tell the court that the discovery keeps rolling in. Discovery that the prosecution has had since last year, and even up yesterday, they just provided us 5 CDs of CBI testing and other crime scene investigation that they've had for at least 6 months, if not a year. We haven't had a chance to go through and see if it's duplicative. If it is, it makes me concerned that, you know, we're just getting buried. But as far as the items identified in the motion that we filed in late June and the inoperable files, I can tell the court this, that the Suzanne spy pen recordings were reproduced to us. And what we don't have is the FBI's enhanced version of the spy pen recording that they utilized in their investigation when they interviewed a very consequential witness in this case. It was a recording they played to this individual. You can hear in an interview they had with this individual that they played him the recording, their enhanced version of the recording. You couldn't hear it, but you could hear that they played it for him, and he was listening to it. That has not been provided to us. The other document that's identified on that late June motion are the hotel screenshots. We know that they use those in the affidavit to build their case or attempt to build the case that they have. And their response, Your Honor, as your court can see, is action discovery. That means basically we say to them, hey, look, we can't open this file. It's inoperable. And they say back to us, oh, here's some table salt. It's totally and completely non-responsive. How about, okay, we'll get you a operable file that you can open. We've still not been able to access the hotel surveillance or the photographs that the prosecution has used and identified in their affidavit. There are a number of other than the late production of the drives and the discs I just indicated to the court, where we don't believe it's not new material collected in the since June 2nd, and there's no excuse for providing this magnitude of discovery this short in time to the preliminary hearing. I want to get to this forensic images that I just indicated to the court, those computers, the Kindle, and the 2 other computers that we noted in our reply, paragraph 7. Those computers. Yeah.
If you don't mind.
Oh.
It helps if I'm going through this item by item, so I understand what you have, what you don't have. Going back to these files that are mentioned, are you, so there's 5 of them, I believe. Of those 5, which ones can you still not access?
Of those 5, we still cannot access them. I will tell the court that, but my expert, discovery expert tells me that he's going to try and chunk them into smaller files before we continue to, argue that we can't open them. I will tell the court that their response that we need a certain kind of reader file that's not true. There's no reader file to open these text files that we can't open. It's clear that they're huge. One of the files is 403 gigabytes. We were able to open one of them that was about an eighth of the size, which is item 5, and we believe that's because it's smaller, and there's no reader file that was necessary to open it. So we think it might be just because they're huge. The prosecution claims they can just open them, but they have a different sorted discovery than we might have. So we're going to keep attempting to do that, and at this time, I don't know if what's contained on those is critical and or duplicative in any way, but we are going to stand by on those files until my discovery expert can give us more information. We've been quite busy trying to work on all this other material.
And let me ask, is there communication between your discovery person and who's ever providing the discovery on the DA's end?
No, I would say that we are doing the best we can, trying to figure out what has and has not. Of course, we don't know what has not been produced, right? But as far as the operable files and the corrupt files that we believe to exist, we notify the prosecution as soon as we know that they're not corrupt, inoperable, or it appears from the affidavit we haven't been produced a document. But no, there's not any direct communication about that. But I am communicating often with the prosecutor where I don't have the burden to do so, but I am doing that.
No, I understand, but some of these issues, it's not that you haven't been provided it, it's you've been provided it in a way that you can't retrieve it.
Yes, you're right. And you're right.
And a lot of that seems to be technological reasons. It's been a while since I was a lawyer, but the way we did it back then was our IT guy would be talking to the DA IT guy to figure out how we can get access to these documents.
No, you're right. And Your Honor, I will just tell the court that those those 5 items, we're not gonna, we don't want to address those today. As I said, we got to work that out. I think that's more of a volume issue than it is a technical issue on our end. But the other issues still remain.
Okay. Well, it wouldn't be the worst idea if you could identify a person that if these issues continue with accessing files, the person, Ms. Iton's IT, should contact in your office.
And that's fine, Judge. We have Detective Robin Burgess here, and he's the evidence technician custodian for Chaffee County Sheriff's Office. And he's going to be that point person from here on out as to any technology issues. We've also worked with investigator, now Commander Walker, and there's been correspondence between the attorneys, myself and Mr. Pendleton, and with staff. I believe it's Tanya Holiday from their office and Crystal Kime from our office. So we're really trying to resolve these issues and to get readable information to them. I also suggested to Ms. Nielsen the very first hard drive that they claimed that wasn't readable, that they contact Rocky Mountain Computer Forensic Lab. That's the outfit that burned those hard drive mirror images. And they're an organization there in Denver that specializes in law enforcement assistance in computer technology issues and have done a lot of the work on this case.
Okay.
I'm trying, Judge.
I'm just encouraging. There's a different situation. Not providing discovery or providing discovery late. Very different to me than providing discovery that for some reason one person's, on one side, they're having difficulty accessing it. And there, I would hope that there would be some cooperation between the defense and the prosecution. Okay, Miss Eaton raised the issue of the enhanced version of the spy pen conversations. Do we know the status of that?
I don't, Judge. That was just brought to our attention, I believe, yesterday. In an email. Yes, yesterday. And so we'll be looking into that. We weren't able to do that between the time of the email and today's here.
Okay. What's brought up in the motion are the files on the spy pen that the prosecution is alleging couldn't access them because there was actually no data in those files. This is a different request with regard to the spy pen. We all are in agreement that the enhanced version of the spy pen recording exists.
I'd have to double check. But my personal knowledge, I don't, but I'm not saying that it doesn't exist. I just haven't read through that part of the report. So I will check with the FBI and see what the status of that is. As well as there were other items that were emailed as well that we will be looking into on an ongoing basis.
Ms. Eaton, are you not able to make out what's said in those spy pen recordings?
Oh, and you can't at all. It's very hard to hear. It's very weak. Especially, this is honestly the one spy pen recording that Suzanne recorded was between her and another individual on the telephone, and her also listening to messages from this individual that are extremely critical to the case. And it's acknowledged by FBI agent Grusing that they're hard to hear. And so they had to actually go back and get them enhanced. And so all that is in discovery. I mean, we know that, but the prosecution doesn't know that, which is a problem right now. But, and you can hear that they played that enhanced version for, otherwise the individual who they played them for would never have been able to hear what was being said. But he had headphones on while he was listening to the recording, so we can't hear it on our end as far as the FBI's interview went. But again, Your Honor, this is like a needle in a haystack, us finding bits and pieces of some of their alleged support for the affidavit in other parts of the discovery that just is taking us time to find, and they don't even know it exists. So it's becoming dependent on us to be able to tell them.
I think I heard either from you or from Mr. Pembleton that Suzanne Morphew's, the contents of her iCloud account have now been discovered.
Your Honor, they were discovered on July 12th. Oh, sorry. Yeah, 10 days ago, July 12th, after multiple requests. And they've had that also for a year, since 2020, pursuant to.
Any explanation of that delay?
Judging on all of these items, we are disclosing them and giving them over to the defense as soon as they come into our office. We have multiple agencies making sure we did that initial disclosure, and as we go back through and identify anything, or it's identified for us, we're getting those items and getting those to defense.
All right, well, let's talk about the items in paragraph 7. The Kindle, the laptop, HP, and the laptop, Apple.
Thank you, Your Honor.
Okay, so what we know is those came out of the Morphew house. We don't know who they belong to. That's what Mr. Pembleton said. Do you take issue with that last part, Ms. Eaton?
I don't know. I know I don't take issue with, yeah, they came out of the house. Exactly. They did come out of the house in the search that was conducted in May of 2020. And they were examined last year as well. And we did receive, and I want the court to know this, and we know this, we did receive some of the items that were searched on the computer. But I will tell the court that search warrant 98, which is where they were given permission by the court to do the examination of these items. And it is a vast search warrant. It is not just hunting and pecking for certain items in the search warrant. The court basically gave permission for a complete search of the computer. It's hard to see what's not permitted, actually. And so we know that it was conducted. And we don't have an image of those computers, number one. Number two, I need to point out, and I know that the court wants me to go in order, but this is related. As I indicated to the court, we keep receiving discovery of items that are not new. We'd received a invoice that has identified on it approximately 13 devices from and only 5 of them we know have been produced to us through discovery. And those are what we discussed already. We've received Barry's iPhone and the reader on Monday, as well as Mallory, as well as Macy's, and as well as an iPad, and then Suzanne's iCloud. So that's what we have received to date. But on this receipt that we received, it indicates another approximately 5 or 6 devices that were collected by the prosecution and received by CBI. And I have a question mark. Have those been examined by RMR CFL, which it indicates they are from the receipt that I have in front of me? I have an evidence intake receipt. Or is this just, and what does this mean? So in addition to the examined items that we know were examined, that I identified in paragraph 7 of my reply, we have a question about these other items, and I can list them if the court would like me to. Otherwise, hopefully the prosecution knows what I'm talking about.
Well, it's either a strength or a weakness by me, or a weakness for me, but I'm a very methodical thinker, Ms. Eaton. And so that's why I'm going through this one by one. And that's how I want to address this.
Okay.
I can keep it straight in my head.
Okay.
I want to go back to the 3 electronic devices in paragraph 7. Have you received, I think I heard Mr. Pembleton say that you've received, correct me if I'm wrong, Mr. Pembleton, that you've received the contents of the return on the search warrant for those 3 devices?
No, that's not correct.
I might have stated that wrong. Okay, well, let me ask the prosecution. What has the defense received with regard to those 3 devices?
Judge, what I show is a working copy of the search warrants that were done on those 3 copies. So, what was actually utilized or taken off, not the forensic image of it, but what was taken off of it. And that's what I'm getting from Mr. Burgess as well.
Ms. Eaton, what Detective Burgess and what Mr. Pembleton are saying is that you would have received the data that was extracted from those items within the parameters of the search warrant. Is that correct?
No. I have, what we have received, we haven't received anything from the Amazon Kindle, 0 from that. We have received hand-picked and selected items from the HP laptop and the Apple laptop, what they decided they wanted to provide us, but we did not receive what search warrant they have pursuant to search warrant 98. We do not have that. It's inaccurate.
Okay. Well, obviously I'm being told by two attorneys, two different things. How do I resolve that dilemma? Obviously, I don't personally know what was discovered.
Judge, as I indicated, that's what came back from our CFL, based on that search warrant. They have everything that we have in evidence besides the overall image of that hard drive.
And Ms. Eaton is specifically saying that they don't.
And I would ask, Your Honor, maybe one way to do it is to ask the prosecutor, where is it? Where can we find it? What's the file name? So that we can identify and we can corroborate what they're saying. But we certainly don't have the Kindle. And as far as the other two computers, we have very limited data. Where is it?
One thing I can tell the court, there are some items that are still pending searches. And I'm not sure if this is one of them. And I'm also aware that there were some items, and it may be the Kindle, I'm not certain, Judge, but it was damaged and wasn't searchable. I don't have that specific detail right now, but in the discussions with the various law enforcement agencies, I seem to remember Mr. Walker, Commander Walker saying that there was something that was recovered that was damaged and not searchable.
And Your Honor, we don't have any information about any of that.
I understand.
Okay.
Okay, and then Ms. Eaton, I'm sorry, you're going to have to repeat yourself on the list where you had question marks. So if you want to do that now, that's fine.
Okay. Do you want the list of all the other discovery items we know we haven't received?
No, I want you to repeat what you were saying about 5 minutes ago.
Okay. So we received in discovery an evidence intake receipt that came from Rocky Mountain Regional Computer Forensics Lab. It identifies 12 devices. The devices that we've discussed are on this list. The devices in terms of Barry's iPhone, Macy's iPhone, Mallory's iPhone, are on this list of items. The question is there is identified a black Apple iPhone. I mean, I can give it by the numbers is the easiest way. The digits are what kind of are the identifying information from RMR. So without using the type of device, it's easier to use the digits. 33570, 33571, 33572, 33573, 33574, 33578. The MacBook Pro is on here, which is 33579. 33580, that's a Toshiba laptop. 33581 is a compact laptop. Oh no, 33581 is a Dell Inspiron laptop. 33580 is a compact Presario laptop. Those items are identified on this evidence intake receipt. And the question we don't have, we would like the answer to that. Have those items been examined by RMR CFL? And have they been produced to the defense?
So you're asking that question with regard to everything but the 3 cell phones owned by the Morphews?
Yep. And I'm hoping that I excluded those items from that list when I read them out to the court.
Well, you identified them at the beginning, so I'm clear. It's another 7 or 8 items.
That's right. Exactly.
And Judge, I don't have that information on the top of my, at my fingertips right now. They weren't in the motion. I didn't prepare for those items. I will be more than happy to work with Ms. Knighton and figure that out and get that information to her, but I don't have that right here for the court.
And Your Honor, I just want to note that the document generated that I'm referring to, the evidence intake receipt, is dated June 14th, 2021, and we just received it yesterday through discovery, and it's signed, it's signed by CBI agent Derek Graham.
Okay. Okay, anything else, Ms. Eaton?
I mean, there's additional items of discovery that have not been produced that we know of. And I'd like to indicate those to the court. And I also like to make a brief argument.
Okay, if you can do the first part now.
Okay. There's a witness with the initials MG. The Celebrite and UFDR files exist, but they have not been provided to us. We discovered this recently and we emailed the DA about it yesterday. That has been in existence, as far as we know, for at least a year.
So are you saying you say the witness initials are MG, and I lost you when you said Cellbrite, which usually to me means an electronic device.
Oh, I'm sorry. It's a cell phone. A cell phone that the forensic, we don't have the reader or the UFDR file or even the data from MG's phone that was searched last year.
Okay.
Referenced in the affidavit on page 92, the FBI showed Barry 26 exhibits, discussed and placed them in front of Barry during their interview of him. The interview was on April 5th, 2021. We don't have the packet of those exhibits. We don't have the collection of those exhibits. We don't know what they were. We cannot find them. We emailed the DA about those yesterday as well. And then we received some body cams in a package of 5. So 1 of 5, 2 of 5, 3 of 5, etc. We package 4 of 5. We don't know what's contained on it, but that is inoperable. We've emailed the DA about that as well.
And Judge, just to interject right here, rediscovered to you this morning. So if there's any issues with that ongoing, let me know and we'll try to figure it out, okay?
Did you hear that, Ms. Eaton?
I did. I think
Okay.
he said he produced that. Okay, so we will look at that and we'll let them know. That is, as far as we know, in addition to the 5 discs we received yesterday. As far as we know, that is the discovery that we don't have, and or is inoperable insofar as the hotel surveillance and video and photographs.
Okay.
Okay.
Mr. Hamilton, can you give me some idea of where we are with discovery? I think the last search warrant I signed was 3 or 4 weeks ago. So I could be wrong, but I wouldn't anticipate a whole lot of new discovery being generated at this time. So I'm trying to figure out where we are, bigger picture. Like, we had this huge amount of discovery at the beginning. It sounds like you've been supplementing that as time has gone by. What does the overall picture here look like?
I can speak to that, Judge. This is a continuing investigation. Miss Morphew's body has not been found, and we keep looking for it. And so there is more discovery being generated as we are continuing to do this work and this investigation. As you know, this case took about a year to get to this point, and there will be more discovery provided. A lot of the search warrants that this court authorized around the time of Mr. Morphew's arrest involved further items that were seized and that have been either attempted to analyze or being analyzed. And that's some of the, I think, the information that Ms. I-10 is talking about that have been transported to RMCFL for analysis. There's a dearth of electronic devices that were found in the initial search of the Morphew residence, the vehicles, and then the subsequent searches of his condominium and the storage units that he had. And so that continuing investigation is happening as we speak. And as we get that information, we provide it on discovery as quick as possible.
Yeah, I understand that part, that discovery is ongoing as you get it. Well, I guess I should ask the question a better way. The initial batch of discovery, everything that led up to May 4th, you think that has all been discovered?
Judge, I believe so, but we also got some discovery from the FBI a little earlier this week, so that will be discovered here pretty quickly. I'm hoping by the end of the day, and that is quite voluminous as well.
Is that new information? And by new, I mean post-arrest information, or is it?
Judge, when we get it, we're not looking through it to determine where it came from. We're just trying to get it over to defense. So I have not had a chance to look through that yet.
Okay. Okay, Ms. Eaton, you said you wanted to make a statement.
I did. And Your Honor, I actually was remiss. There's one more type of file. And I just want to say, I don't have any faith, basically, that the files we're getting from the FBI are going to be newly generated reports based on the 5 discs that we received yesterday from CBI. But we also haven't received, the court ordered that, a discrete type of email and text messages between law enforcement and witnesses be produced to the defense. And while there have been emails that have been produced by the prosecution, they are not the emails that we expect to see in a case like this and or that are discoverable. So the emails that we've seen are asking for search warrants, asking for a follow-up from search warrants, et cetera, but not the type of emails that we know likely to exist. So that's also a lacking area. And we did email the DA about that as well. So can I just have a second to consult with my co-counsel?
Yeah, maybe cover your microphone.
Okay. All right, thank you, Your Honor. I just wanted to now kind of let the court know where we're coming from after we filed all these motions. We filed a motion for contempt, and we sit here and the prosecution doesn't know what discovery they have and they don't have, which obviously hobbles the defense. They're in violation of Rule 16. They're in violation of a court order, and they're in violation of the Constitution. And, you know, this is really for Mr. Morphew, who's now sitting and stuck in a jail cell, to understand that this is not the way it's supposed to be. This is not how the justice system works. Prosecutors, you know, they have an exalted status in the criminal justice system, and they have extremely high disclosure obligations. That is, and they play such a special role in the justice system because they have such control over the life, liberty, and reputation of any other person in the United States. They have the most power, probably, and unanswerable than nearly any other official in the United States. And we consolidate this power and give them this discretion, but they have to be held to it and ensure that they're going to use their resources to answer when they file charges against a human being. And the reason this is, they're using an excuse here that we have so many experts, we've really done an extremely thorough job of investigating, and we can't get all the information quick enough. But the disparity in the resources shouldn't be held against Mr. Morphew. They have the benefit of litigation, investigative resources that the defense doesn't have. They have the ability to shine a badge on anybody they want to talk to. And they do this really and they did this for a year, unbeknownst to Mr. Morphew, where he just ends up getting arrested when they've already used these vast forensic services, computer records, hired experts without limitation, and have huge institutional involvement with undercover investigators, informants, FBI agents, CBI agents, and then they get to the place where they arrest him. As the minute they arrest him, their duties and the clock starts running as far as Rule 16. And the court knows their disclosure requirements are spelled out. There's no room for interpretation. The rules of discovery are to ensure a fair process and to protect somebody's innocence. These are important because there's such abundant power that the prosecution holds that we have to maintain society's faith and Mr. Morphew's faith in the integrity of the criminal justice system. So the standard of review, as the court knows, is whether or not they failed to turn over the evidence. That's it. Whether they complied with discovery orders, or whether or not they failed to disclose evidence tending to be favorable. That's it. Mere negligence or ignorance does not negate a claim that discovery was not provided. Materiality is actually not even required. Neither is the prosecution's intent or bad faith. However, in this particular case, we believe that the delayed production and the non-disclosed discovery contains material, favorable, and exculpatory evidence consisting of Brady evidence. The prejudice here is what's important. Mr. Morphew's constitutional right to show this court, to have due process and show this court in 2 weeks that the affidavit does not prove probable cause or that there's proof evident presumption great of a conviction is going to be very difficult. As the court knows, Mr. Morphew was jailed without a bond on first-degree murder on May 5th, a year after Miss Morphew went missing. A massive accusation. She's still missing, and there's no physical evidence that Miss Morphew is deceased. If so, by who, when, or what caused her alleged death? Only speculation. The prosecution chose to arrest Mr. Morphew on this specious evidence on May 5th, and they have a right to choose when to arrest somebody when they believe they have probable cause. But when they decided to arrest him, the clerk started for them to fulfill their prosecutorial duties to provide discovery in accordance with the rules and the laws, and not to violate Mr. Morphew's constitutional rights to effective counsel, fair hearing, due process, and bail. Well, now we're here and we're hobbled by the ability to protect Mr. Morphew's statutory and constitutional rights to illustrate to the court that the proof is not evident and the presumption isn't great, nor that there's probable cause in this case, because they have violated the rules and the Constitution and the court order. And he is not allowed to bail out. Mr. Morphew had a right to a PH in 35 days from May 27th, the date of the setting. And he waived that right and agreed to set his proof evident, presumption great, and preliminary hearing 72 days from the initial setting. We knew it was going to be a big task to take on all this discovery that the prosecution had. But Mr. Morphew expected, as he consulted with us, that if he set the PH out that far out, that the discovery the prosecutors and law enforcement have had for over a year and used to formulate their affidavit would be produced by the court's order deadline of June 2nd, 2021. Mr. Morphew expected that his team could be prepared and have time and find the necessary experts and consultants who had the time to investigate from the discovery and analyze the data in the discovery in order to challenge the witnesses who drafted and contributed to the affidavit in time for the proof evident, presumption great, and preliminary hearing. And then a heap of Rule 16 and material discovery was just produced this week, 47 days after the court order. This was after multiple requests, which we don't need to make, 15 days before the preliminary hearing. Their delays, inoperable files, and missing discovery prejudices and impedes Mr. Morphew's ability to challenge their speculative belief that they had probable cause in violation of his due process rights, effective assistance of counsel, and ability to argue for his constitutional right to bail. And as the court has heard, most of this noted discovery is not paper discovery, it's complex electronic discovery, forcing Mr. Morphew to hire experts and consultants to ascertain not only what was withheld, but what is operable and what it all means and how it was included, excluded, omitted, contradicted, or inconsistent in the affidavit. And in the meantime, Mr. Morphew rots in a jail cell, deprived of his liberty and humanity, while the prosecution slowly ekes out what discovery they believe might exist for an imminent and critical hearing, asking the defense multiple times if we have everything, when it's not our burden to request, when it's clear that we don't have everything, and we don't know what we don't know. And the question here is reminiscent of the People v. Bueno case, as the court might know, is a pretty seminal Colorado Supreme Court recent case regarding discovery, where the court affirmed the notion that the defense need not search for a needle in a haystack. We don't need to look for it and figure out that it's not there. That's inconsistent with Brady. And as the court says, it lends no support to the notion that defendants must scavenge for hints of undisclosed Brady material when the prosecution represents that all such material has been disclosed. And now we do know that what was just produced 3 days ago is hugely material in this case. Now, we have these violations And now the DA's office, after us asking them a few times, what witnesses are you going to be calling at this prelim? So we can try and get prepared, even though we don't have all the discovery that we need. They advised us yesterday they intend to call 18 witnesses for the 4-day preliminary hearing. This hunches seem to be something that the prosecution tend to hear. Well, we have a hunch that between these discovery violations and their intention to call 18 witnesses for a preliminary hearing is a delay tactic to keep Mr. Morphew jailed as long as possible without the ability to post bond. They want to cause Mr. Morphew to go mercy, so he'll continue this hearing. But the defense and Mr. Morphew wants no part of that delay. He wants this hearing, but he wants a fair hearing. And he wants a fair hearing in light of the fact that the prosecution has violated the rules in the Constitution. So you get here. The question is what to do to craft an appropriate sanction that eliminates the prejudice that flowed from the discovery violations. As far as Rule 16 goes, as the court knows, the court has broad and absolute discretion to impose sanctions that will cure the prejudice, protect the integrity of the truth-finding process, and deter future misconduct. And as the court also knows, that the court can impose discovery sanctions that will adequately remedy the violation and level the playing field. And in doing so, the court should consider the reason for the delay, any prejudice a party suffered because of the delay, and the feasibility of curing any prejudice through a continuance. However, when there is willful misconduct or a pattern of neglect demonstrating a need for modification of a party's discovery practices, harsher sanctions may be imposed. Otherwise, a court should use sanctions only as a means to cure the prejudice resulting from the discovery violation. And here we ask the court to take judicial notice of the 11th Judicial District Attorney's Office pattern of neglect and violation of Rule 16, Brady, and court orders that have occurred just in the last 6 months. It's clear they need to be deterred and to modify their prosecutorial discovery practices. They have violated discovery in the following cases, and the courts have ordered sanctions in the following cases. 20M322, Judge Robach, DA Linda Stanley, the court found Rule 16 violations for failure to turn over medical reports from an alleged victim prior to trial. The court sanctioned the DA. Case number 20CR52, Judge Wenner, the date of the order was 7/13/21. Court entered sanctions against the district attorney's office and ordered the people to pay attorney's fees for their lack of responsiveness to the court orders for failing to provide discovery. And this was even before the preliminary hearing. Case number 20CR434, Fremont County, Judge Lama, DA Steve Sullivan. The court granted Rule 16 sanctions in a case where it was a second felony trial in 2 weeks where the prosecution made belated disclosures. In that case, the individual was in custody for a year and the items were in possession of law enforcement for over 10 months. Case number 21CR94, Judge Murphy, DA Jeff Lindsay. The minute order reflects 3 days ago, the day that we got the hard drive, July 19th, 2021. It appears that the court continued the preliminary hearing for 3 days due to Rule 16 violations. We don't have all the information, but the public defender, the minute order reflects that she stated that the defendant was prejudiced by the continuance. 19CR524, Fremont County, Judge Lama. Order 5/22/21. Court opposes a sanction of excluding evidence at a trial. Case number 20M224, Judge Green, DA James Wagner, date 6/28/21. The court ordered Rule 16 violations and said a continuance would cure it. 20CR448, Fremont County, Judge Lama, DA Elizabeth Drake. Material evidence was produced 3 days before trial. Discovery violations imposed. The last one, number 8, 19M120, Fremont County, Judge Plotz, DA Linda Stanley. Looks like the order was around July 6, 2021. It's suppressed. However, what's not suppressed is that Judge Plott stated he found 2 Rule 16 violations for the DA to fail to provide recordings of voicemails and failure to provide prior calls to law enforcement. Sanction on the first was preclusion of the testimony. In the event of a conviction, he'd consider a new trial on the motion. Your Honor, Rule 16 has been in existence since 1985. Landmark cases, Brady v. Maryland, since 1963. Kyles Whitley since 1995, and Giglio 1972. And yet, these prosecutors do not appear deterred by Rule 16, by their own sanctions, or any U.S. case law. Ms. Stanley may be new to the 11th Judicial District, and maybe even these prosecutors, but they have all been peace officers for quite some time, and their power or duties as prosecutors do not get a discount rate for less time in the 11th or as a prosecutor, especially not when you're accusing Mr. Morphew of murder when there's no physical evidence that a murder has occurred and he is being held without a bond. The sanction here is not a continuance. That will not cure the prejudice or protect Mr. Morphew's due process rights when we know the case will be continued for months from here. And all the while, he will be wrongly held without bond when they sit on discovery. It does not deter their future misconduct, nor will it induce them to modify their prosecutorial practices. It will be a great prejudice to Mr. Morphew to continue the PH and to give them more time to give us the discovery they have had in their possession for over a year, forcing Mr. Morphew to be held hostage by their specious affidavit and their violation of rules, constitution, and court order. All the while, this continuance would give the prosecution a benefit to continue giving them the slow train of justice, using excuses like there are a lot of agencies involved, they're busy, while they hug their kids at night, get to drive home, drink water from their own faucet, privately use their facilities. All the while, Mr. Morphew loses another day of sunlight, of seeing his daughters and communicating with his lawyers freely. The sanction here, Your Honor, we're not asking for dismissal of this case. We understand that it is an extremely severe sanction. While we believe the case should be dismissed and should not have been charged, that is an extreme Rule 16 sanction. We get that. We are not asking the court to suppress the discovery that was disclosed after June 2nd. We know that sanction is also not favored in the courts, as it impairs the truth-seeking function of the criminal process. And we actually believe the discovery, once we get it and can analyze and investigate it, will actually prove Mr. Morphew's innocence. So we are asking for one of 2 sanctions. The first sanction, bond. Our first and least severe sanction is that the court set a reasonable cash surety property bond. This will cure the prejudice. This will deter future misconduct. It will preserve the truth-finding process, and it will likely cause a prosecution to reform their discovery practices. This court has absolute discretion to impose a sanction. It is the most fitting and appropriate, and it is the least extreme of the sanctions. Not only is the court availed to any other order it deems just under the circumstances according to Rule 16, but the Constitution and statute supports that a bond be set. The prosecution violated the Constitution, and the Constitution trumps the statute. The court can answer this, and the Constitution eclipses the statute. In addition to that, Mr. Morphew has a right to bail under Article 2, Section 19 of the Colorado Constitution, where it gives a criminally accused the right to bail bond pending the adjudication of the charges against him. As the Constitution states, all persons shall be bailable by sufficient sureties pending disposition of charges. And this provision of Colorado Constitution is violated if he is denied bail. And at this point, the court can comply with the Constitution and give him bail. Furthermore, although Mr. Morphew is held without a bond pursuant to Statute 16-4-101-1A, this statute only authorizes a defendant to be held without bail for a capital offense, where the proof is evident or the presumption is great. Mr. Morphew is not charged with a capital offense. We know there's a 30-year-old case, Tribe versus District Court, that suggests that a first-degree murder charge is a capital offense, regardless if the death penalty is imposed. However, there is more recent authority that points out that Tribe does not address the issue of whether a legislature can abolish capital punishment while still calling penitentiary-only crimes as capital, for the purposes of denying bail under capital offense exception to a constitutional guarantee of pretrial release. That's the Amir case, 458 P. 3rd 390. It's a 2018 case. Regardless, Your Honor, in the very least, the term capital offense is ambiguous, given that on February 26, 2020, the Colorado legislature passed SB 2100, repealing capital punishment for offenses charged after July 2020, and Governor Polis signed that bill on March 23, 2020. The second sanction, if the court does not find that that would cure the prejudice or that that's too harsh, which we don't believe, the second sanction we request is reducing the first-degree murder charge to second-degree murder. We do not believe the evidence we have seen supports a murder charge, period. But this is a second sanction we believe the court has the authority and should impose. Our Supreme Court has noted that the court is permitted to dismiss charges when, one, there's constitutional grounds, two, to protect the integrity of the judicial process, and three, insufficient evidence to support the prosecution, or four, when authorized by statute. And the court can look at the Renander case, 151 P. 3rd 657, Colorado App 2006. And there's other case law if the court would like that supports those factors. The court has absolute authorization to do that. It is not a separation of powers issue, and the court can do it under those circumstances. And there's a slew of case law that permits the court to do that. The court can also amend or reduce the charge under certain circumstances, and the court can look at numerous cases, including Hunter v. District Court, 519 P. 2nd 941, 1974, that discusses a court's authority to amend or reduce a charge. Your Honor, I know we didn't talk about this part, but a non-sanction we would request is a testimonial hearing on discovery. It's not a sanction, should not be a sanction. That should be an absolute order in this case. As a court can hear, the DA's office is completely unaware of what discovery exists, what's been provided, what hasn't been provided, and what is coming down the pipe. And we'd ask that the court set a hearing where they can answer to those questions and they can advise the defense counsel where actually this is, if they in fact have provided it. The prosecution noted that they were going to they needed a little extra time from the date that the defense wanted the initial discovery, and said, you know what, we'll get it to you on June 2nd, a little later than the defense wanted, because we're going to bait stamp the pages. That will help the defense. Well, they didn't bait stamp the pages. So we're dealing with nearly 2 terabytes of discovery and nothing is bait stamped. And so it's taking us an extremely long time to be able to go through it. But I'm going to tell the court that's not the reason why we're here today. We took the onus on to look through and hire the experts we needed in order to get through this discovery so we could get Mr. Morphew out of jail. And so we took that on. Our complaint is not that. Our complaint is that they didn't provide us material discovery until 3 days ago, period. And if their complaint is, oh, these phones, it's just your expert that couldn't operate them, it's your fault, you couldn't do it, why are we having to ask for them in the first place? And why weren't they provided on June 2nd? And if they had provided them on June 2nd and they were inoperable, well, it wouldn't have been a whole nother 2 months till we received the operable drives. So that is our argument for the discovery. And I know the court has not placed at issue the contempt motion, and we do have sanctions and request regarding that motion, but I'll put that aside until the court is requesting being heard on that.
Okay, Mr. Lindsay or Mr. Pendleton?
Well, first off, Miss I-10 keeps repeating and beating a drum that we've had this discovery for over a year, and that's just not true. We have had a lot of the discoveries for a year, but that was the search, and the search was a huge funnel. And as that funnel narrowed down and identified Mr. Morphew as the suspect and the defendant in this case, we started getting more and more information. And so to say we've had all this information for over a year, it's just a misstatement. And she keeps saying it, and it's just plainly false. Now, I understand we've had it, and we're working on it. We'll continue to work on it. I have had discovery discussions with law enforcement on this case almost on a daily basis, Judge. I understand my obligation. I have never shirked my obligation for discovery, and I have had conversations with Ms. Itan and Ms. Nielsen at least a dozen times trying to remedy issues that they say are problematic. These discs that just got released today, those are CBI litigation packets for the analysis that they did. That is something that we don't normally get and give to the defense until a case is set for trial. I expect this case to go to trial. We got those in advance and we provided those today in discovery. So that's not a huge amount of information other than it is the information surrounding the DNA and all the testing that was done by the Colorado Bureau of Investigations. This case is a massive case. The court acknowledged that several times. There are a number of law enforcement agencies involved in this case. We don't typically work with the Federal Bureau of Investigations, and working with them, we have been adamant with them as well, and Colorado Bureau of Investigations and the Sheriff's Office, that discovery is not an option. It is obligation. It is mandatory. And there has been no demonstration whatsoever from the defense that we have withheld exculpatory information. They can raise and say it's exculpatory, but unless there's something specific said, I don't think the court can make that finding. Moreover, Ms. I-10 keeps saying that we violated the Constitution, Well, the Constitution of the United States is different than the rules of discovery. Discovery is governed by Rule 16. Constitution of the United States says that there are two rights that a person has, and that's the right to discovery of exculpatory information. So I'm not trying to say and minimize it, that the violation of the Constitution is just, talk about a specious argument. That's a specious argument. We get it, Judge, we give it. And we have continually tried to work with Ms. Itan and Ms. Nielsen into getting them information that they're claiming or they're saying, hey, we get it. Well, if we don't have it, we can't provide it. We go out and get it as soon as we hear. I can tell you, I've had conversations with Detective Burgess, with Commander Walker, with the agents from the FBI, with agents from CBI. Again, almost on a daily basis about discovery, how important it is and that we need it. We have, again, tried to work with them. We have given them 2 separate hard drives. I've sent detectives to Denver to pick up hard drives. I've sent relays to the defense counsel. We've made it available either through their investigator or we've met them at their office to give them information. I've suggested to them ways I think they can look at this information. When we downloaded that WinZip file, we were able to look at that information. Initially, when it came over, we couldn't look at it. We downloaded this simple reader, it worked just fine. We have provided multiple copies of the phone. And so my argument, Judge, is we provided this stuff. Now, they're claiming that we have it, and we haven't given them the access to it. Well, Rule 16 says make it available. It doesn't say we have to stand over their shoulder and open these files and give them the expertise. That's kind of on them. If they want to look at this information, then that's on them. Make available doesn't say we have to give them, instructions 1 through 15 as how to open electronic data. This is a massive case. And one thing I'd like to address that Ms. I-10 just recently brought up is they asked us for a list of witnesses, and we sent them a list of witnesses. We're not required to under Rule 16. We're not required to by this court order. Trying to work with them, trying to help iron out issues and give them heads up. I sent them a list of witnesses, and now it's us trying to get it by convenience. That is, again, talk about a specious argument. That is absolutely not what I was trying to do. I was trying to work with them and try to understand, help them understand what witnesses we're intending on calling. Now, are all those 18 witnesses going to be called? Probably not. But are some of them going to be called? Absolutely. The majority of them will. But to say that that's my attempt to buy a continuance, that's just patently false argument and a smokescreen that Miss I-10 is throwing out at you. It is complying quest, trying to work with the defense in a good faith manner. That's what this case is about. Everything that we have done is in good faith. And there is absolutely no way to do bad faith. And that's one of the things the court considers when it looks at what to do with these issues. I think what the court suggested and what the court hopefully is going to order is there be a better flow of information between the experts the defense have hired and the experts we have. I'm more than willing to do that. I identified to the court Detective Burgess, anybody from CBI, anybody from RMCFL. We make it available. I suggested that to Ms. Meeks that they contact RMs. And as far as sanctions, I don't believe there are any sanctions, Judge. I think that what the court says is, let's keep working on this. We're ready for prelim. We'll be going prelim on August 9th and 10th, and then the subsequent next week after that, and we'll be ready to go. I'm not trying to buy a continuance. As far as the bond issue that she's asking for, the remedy that is suggested by the courts is the least restrictive sanction is favored. That's what the court said. People versus District Court 808 Pacific 2nd 831. And what it says is the imposition of sanctions serves a dual purpose, protecting the integrity of the truth-finding process, and the attorney and prosecutor in place for misconduct. There has been no misconduct, none whatsoever. I challenge anyone who is on this case to suggest there has been a period or any type of misconduct on this particular case. The court goes on further in that case and says, in serving first protecting the truth-finding process, we have required the sanction to be no more restrictive than necessary to protect the defendant's right to due process. And so similarly, in serving the purpose of deterrence, the court should impose the least severe sanction that will ensure that there is full compliance with the court's discovery orders. Actually, the court looks at is the reasons why disclosure is not made, the extent of the prejudice, the opposing party, the feasibility of rectifying the prejudice by a continuance and any other relevant circumstances. That's what this court is faced with. And then what the defense is arguing is a bond set. That's a pretty restrictive sanction. Not the least restrictive. It's very restrictive. I would argue the court has no authority to set bond under 16.4101. The only time the court has authority to set bond on an F1 first degree murder, which Mr. Morphew is obviously charged with, is if the proof is evident, it's not evident, or the presumption is not great. We haven't got there yet. That is set later in August. And that hearing will be conducted by this court, and that court will make that finding at that. The other sanction they're suggesting is drop it down to a second degree murder. I don't believe the court has the discretion to do that either. People have the burden of proof. People have the ability to bring charges. We are aware of our obligations under Rule 16. We are working diligently to provide that information to the defense. We are communicating with them. We are doing everything we can in our power to make sure that they get the information. Now, there was a question of what do we have or what do we don't have? Well, we are getting it and literally putting it in the discovery queue. We get it. We are then spending time looking at what we have over the course of the period of time. And so to say that we don't know what we don't have is an inaccurate statement. It is such an obligation, such an important part of our job that we send it through discovery first and foremost, and then we work from it after that. So I suggest the sanction is the court order the continued 16. There would be better flow of information between the defense. I guess that's not even a sanction. What I suggest the court order is there be better communication between the two parties, that there is identified person who is capable of discussing technology issues, because that's what this case is about. That's what this issue the defense is raising is technology. And we're going to give it to them, and it may not be readable. Do what we can to help them with it. But certainly, we're not giving them instructions how to do it. We'll continue to comply with Rule 16 as we have. Thank you.
Okay, thank you, Mr. Lindsay. Okay, there's no disagreement here that I entered an order on May 27th that the prosecution provide discovery to the defense by June 2nd. We are all aware that Rule 16, Colorado Criminal Procedure Rule 16, covers flow of discovery both ways. We're all clear on the prosecutor's obligation under that rule. We're clear that his obligation extends to people that work in the prosecutor's office and also to law enforcement. There were several specific items cited by the defense in their various motions, and then Ms. Eaton raised some other issues during this hearing. I want to go through the ones that were raised in the motion. The mirror copies of the iPhones, there was some delay in providing those to the defense. That delay is, as I mentioned earlier, was because the Rocky Mountain Forensic Laboratory had to create a new mirror image because the image they had that had been searched was no longer a mirror image. There was some delay in getting that done. It was done. It was then provided to the defense. The defense expert could not copy the mirror image. There was statement by the prosecutor that they could access it but not copy it. I'm not sure if that first part's true or not. But in any event, it didn't work for what the defense needed to do. And when notified, the prosecution then did the same process again, got another mirror image created and delivered it to the defense, and that seems now to be operable. So while that was past the deadline set by the court and therefore a violation of Rule 16, I really can't find that that was willful misconduct on the part of the district attorney's office. There was the initial delay. There was the problem with the first hard drive. And when they got notice of that problem, they remedied it as fast as they could. Ms. Eaton told me to stand by with regard to the reading of the files. Then we have the issue with the spy pen recordings. Ms. Eaton indicates that as they are now, they're not decipherable, but there was an enhanced version created by the FBI that apparently is decipherable. That has not been provided to the defense, as far as I know. So there is a discovery violation there. The remedy for that, I'm going to order Mr. Hamilton, Mr. Lindsay, that you provide that recording, the enhanced version from the spy pen within 7 days of today's date. Copy of Suzanne's iCloud account was provided to the defense July the 12th. So there was a violation of the court's order by about 5 weeks. The remedy, while it's already been remedied, it's been provided late, but provided. The devices listed in paragraph 7 of the motion, the 2 laptops and the Kindle, there's significant dispute about what the defense has or doesn't have. The prosecution is saying they have what we have, which is the contents of those devices within the parameters of the search warrant. Ms. Eaton is saying, I don't have any information from those devices. So it's hard for me to determine whether there's been a violation because there's such a discrepancy in what the attorneys are telling me. So Mr. Lindsay, Mr. Pendleton, I'd like within 7 days, filing with the court indicating to me what the status is of the discovery on those devices. Some other things that Ms. Eaton brought up today, I'd also like some resolution on so we don't have to keep doing these types of hearings. She listed 9 devices that were in a receipt from the Rocky Mountain Forensic Laboratory. She's not aware of the status of those devices, whether they've been analyzed or searched, and the results. So also within 7 days, if you could get her file with the court an update with regard to those devices. If you didn't write down the numbers, I'm sure Ms. Eaton can provide them to you in an email. Ms. Eaton brought up the witness MG, whose cell phone was apparently searched, and she believes there's a Cellbrite result from that search. If you can provide either a status of that search or provide the data within 7 days. She mentioned that when the FBI interviewed Mr. Morphew on April 5th of this year, he was shown 26 exhibits. She is not clear on what those exhibits were. So what I am also requiring is either a report by the FBI agent indicating what those exhibits were, or providing Ms. Eaton, a copy of those 26 exhibits within a week. The issue with number 4 of the 5 body cam videos seems to have been resolved. And Ms. Eaton, I'm not prepared at this hearing because I have no idea what the underlying facts might be. Your issue with regard to my order on emails between law enforcement and the prosecution, if you want to file a pleading with regard to that, I think that would be a better way to do it. Otherwise, I'm kind of flying blind.
Okay.
In a more general sense, I need to note that the prosecution here did provide an enormous amount of discovery on time on June the 2nd, a terabyte of information. Discovery, especially in a case this large, is not a perfect system. The flow is not seamless, and in this case, it is not seamless. But this is not a situation where there hasn't been disclosure. It's just late disclosure, or there's been issues regarding access to the disclosures. The discovery process could have been better coordinated. The investigation here was over a year. It was the goal of the investigation was to lead to charging somebody. So the agency should have been aware that if they reach their goal, this discovery would have to be provided in a manner that's consistent with Rule 16 and also comprehensible to the recipient. So the coordination here certainly would have been better, and I hope going forward it is better. Ms. Eaton, Mr. Morphew, it's not lost on me that this is not just a situation where we have some late discovery or inaccessible discovery leading up to a preliminary hearing or probable cause hearing. This is different to me because Mr. Morphew is being held without bond. It takes on more gravity than would a regular preliminary hearing. I'm glad that we did this hearing. I'm glad that these discovery issues have been brought to my attention, because if this does appear to be a pattern, my response might be different going forward. But at this time, I can't really find that it's a pattern. I'm hoping that this is just a result of the enormous amount of information that had to be disclosed within those few weeks, and not a situation where, as new evidence is being generated, new reports being generated, that there's delay in providing those to the defense. We will see. So there are violations here. That's frankly the easier part of the analysis. The bigger question is, what should the sanction be? I am obligated to choose the least restrictive sanction. In looking at some of the cases cited by the defense, I think they're distinguishable. The Great House case cited by the defense, in that case, there was actual destruction of critical evidence. It was blood evidence by law enforcement. And in the Mucklow case, there was purposeful non-disclosure of exculpatory evidence by the prosecutor. As far as I know, we don't have destruction of evidence here, and I cannot at this time find that this was willful or purposeful on the part of the district attorney's office. I don't believe that the first sanction being requested, I don't think that I have the ability to abide, even if I thought it was appropriate. Both sides have cited CRS 1614-101, which does not allow bail for capital offenses if the proof is evident or the presumption great. That's the hearing we're having in a few weeks. So by statute, I don't think I'm allowed. And then Ms. Eaton stated toward the end of her statement that this might not be a capital case. I don't know the answer to that, but I do know the change in the statute. By my reading of the statute, 18.3401, A, Roman numeral V, A.1, and A of the same statute seems to indicate that the abolition of the death penalty applies for cases where the offense occurred on or after July 1 of 2020. So my reading is it's the offense date, not the charging date. And therefore, this would still be a capital case. Again, this was just brought up at this hearing. I haven't spent a lot of time researching it, but that was my recollection in reading the legislation last year, and that seems to indicate, the statute seems to indicate the same. So I don't think that's sanctioned, even if I thought it was appropriate. For the same reasons that I haven't found willful misconduct, I'm not going to issue the contempt citation. So that's a long-winded way of me saying there have been violations. There needs to be better coordination between the prosecution and law enforcement, and the prosecution and defense. If this becomes a pattern, my response as far as sanctions might be different. I say that all in the context of Mr. Morphew being held without bail, which raises the stakes here significantly, in my opinion. Okay, Ms. Eaton, did you need anything additional as far as the record on the discovery?
No,
Mr. Pembleton or Mr. Lindsay?
No, thank you, Judge.
One thing I wanted to bring up, since I have everybody here, and I don't want anybody in the public to think I'm hiding the ball, but I do not have any intention of, when we conduct the proof evident presumption grade / preliminary hearing, of having that broadcast by WebEx. It's not a hearing where expanded media coverage is authorized. The reason we've been using WebEx over the past 14 months has abated. I have the approval of Chaffee County Public Health to have my courtroom, to have the public in my courtroom, as long as everyone is wearing a mask, unless speaking, and as long as I have 3-foot distancing That allows me to have about 25, 26 members of the public in my courtroom. And I would utilize space in the jury box if any family members want to attend the hearing. I will say that conducting large hearings like this with WebEx on is a distraction to me. At the proof evident hearing, I am the trier of fact. I need to be paying attention to what is happening in front of me in the courtroom. And I don't want to have my attention divided between what's happening on a screen and what's happening in front of me. So because it's not an expanded media coverage eligible hearing, because I can have public in my courtroom, and because I'm the trier of fact and I need to be paying attention, I have no intention of running WebEx at that hearing. Does anybody object to that?
No, Judge.
No.
Okay. Then unless there's anything else,
Your Honor, I think Ms. Nielsen would like to address something with the
Oh.
court. Can I mute myself and you unmute her?
certainly. Okay, you're unmuted, Ms. Nielsen.
Thank you, Your Honor. Better turn this off. Can Your Honor hear me? Sorry about the feedback.
I can, and that's usually because there's two devices next to each other. But Ms. Eaton seems to be muted, so I don't know why I'm getting that feedback.
Let me turn mine off and I'll go on to Ms. Eaton's computer.
Okay.
Can Your Honor hear me?
Yes.
Thank you. Your Honor, as Mr. Lindsay said, sorry, we're still having feedback, but I think it's corrected.
That's good.
I am concerned about the witness list and the representation that there's going to be 18 witnesses or the majority of 18 witnesses. We have a 4-day hearing set, and our request would be that the time be divided equally. I don't want to have, I just can't see how the court can get through the direct examination and the cross-examination of 18 witnesses in 4 days. I think it's impossible. I think that's like a 3-week trial. We are anxious to get to the proof evident presumption great hearing and to be able to request bail for Mr. Morphew. We don't want the case to extend, this hearing to extend beyond what it is set for. So I'm asking the court for some guidance in terms of how are we going to manage the time in the hearing? And if maybe the court could make an order that time will be equally divided.
Mr. Lindsay, sometimes when you're asked for a list of witnesses, you err on the side of caution and give everybody that might possibly testify. Are these 18 witnesses like that you are going to call?
So the court is correct with the initial interpretation. I gave them more than I think is going to be called, most likely, in an abundance of caution. So, for instance, we have about 4 witnesses that go over the crime scene at the Morphew residence. I don't think we'll need all 4 of those witnesses. We also have some scheduling issues with some of the witnesses that they're not available. But I gave a list of the witnesses that I indicated were subpoenaed to the defense. I guess I don't want to be hamstrung with, you didn't tell us we're going to call this witness and we object to, that's just not the way prelims work. And, you know, if we don't provide that name of that witness and the defense says we are not on notice, then I think it's going to cause further delay and further objections by the defense, which again, is contrary to the normal process from hearing.
Your
Well-
Honor, oh, I'm sorry.
Give me just a second. Go ahead, Ms. Nielsen.
Your Honor, again, I would ask, I don't want to add more days. We want to resolve this issue. We want to be able to argue that Mr. Morphew should get bail and that there's no probable cause. We want to have a determination made. I think the prosecution should have to make some decisions here, and I think the most equitable way to do that is for the court to assign time and to keep time of they get half of the time allotted and we get half of the time allotted. They're going to have to make some decisions on what witnesses to call. I think that's always the case. Given the late discovery in this case and that we're, not getting the hard drive until this Monday, I would ask that the court consider a further sanction that they provide a good faith witness list to us so that we can be prepared for the witnesses that they are going to be calling in 7 days.
Mr. Lindsay, do you think you could give the same 18 witness list, but maybe highlight those that you are definitely going to call?
I can, Judge, and I don't know what the court wants me to address the time issue or not.
I don't. I think it's nearly impossible, in my opinion, to keep exact 50-50 time in a hearing like that. I think what I'd like to do is get through a day or two of that hearing, see how far we've gotten. And then if it looks like things have bogged down, we'll address it then. I'm with you, Miss Nielsen, and I would guess Mr. Lindsay would agree. I think 4 days is enough to get through a hearing such as this. I want it to be completed within those 4 days. If it helps, well, no, let me take that back. There might be time later that week if we have to utilize it, but I won't know that for a little bit. But I'd like to get through at least a day, maybe a day and a half, see where we are. And then if it looks like we're having a time crunch, we'll address it then.
Okay.
Your Honor.
Oh, sorry.
And Mr. Lindsay will provide you with that same 18-person list, but give you an idea of the witness he's definitely going to call.
Thank you.
And I was going to ask the defense for a list of their witnesses they intend to call.
Do you intend to call witnesses, Ms. Nielsen?
Judge, I think there's a possibility, but I don't know until they call their witnesses and put on their evidence whether we will decide to call witnesses or not.
Okay. Neither side has an obligation to say who they're going to call as a witness at the prelim. Prosecution has done that at your request. I don't think I can order the defense to do that. I'm not aware of a rule. It seems
I'm
like
not either, but I would ask that if they intend on calling somebody or even reasonably consider calling somebody, that we get that information as well in the spirit of fair play.
unfortunately, I can't cite to the spirit of fair play. So I have to leave it there. Okay, anything else, Ms. Nielsen?
Your Honor, I do anticipate, in addition to Ms. Eaton, that we will have an investigator, probably 2 investigators with us. So just for planning purposes in the courtroom, we'd ask for 2 seats in addition to ours.
Okay. We'll probably have your investigators seated. If you remember, the jury box would be to your right
Yes.
next to you. That's where they'd be seated.
Perfect. Thank you.
Okay. Unless there is anything else, the court will be in recess.
No, thank you.
All right, thank you all.
Thank you.
Okay, thank you, ladies. We'll see you soon. Bye-bye. All right, guys, what do you think? What do you think? I kept up with chat that whole time, and this was pretty mind-blowing. The spy pen. If you guys missed the spy pen, Suzanne had a spy pen, and we know that there was audio on it because she said they couldn't make out the audio. It was garbled. So I don't know if there was actually video, but I am just like crazy, like happy that Suzanne recorded some stuff because this might actually help bring justice. Very, very huge. All right, you guys, this has gone on for, oh my gosh, 2+ hours. So thank you for being here. Thank you for being respectful. And on your way out, oh my God, Soaps by Sammy, thank you so much for your support. I appreciate you. And real quick, before we go, not only could you give this video a thumbs up on your way out, but I have started releasing true crime shorts. It's like short videos, true crime in half of your time. And I'm going to release those on Tuesdays and Thursdays every week. And they might be old cases, unsolved, cold, solved, I mean, whatever. And if you have any case suggestions, if you want to see me make a true crime short out of a case that you've seen, go ahead and email me, jisforjustice@gmail.com. Just give me the case. If you do have information, great. If you don't, research team, we can research it and put together a true crime short. So make sure you check those. And all of the members of YouTube and my Patreon get early release to those shorts on Mondays and Wednesdays. So you don't have to wait till the Tuesday, Thursday. So that's an extra perk of being a member. Also those cool emojis, the berry head, you know. So anyways, thanks you guys for being here. I appreciate you. And be on the lookout for some exciting events, interviews coming up soon on J is for Justice. And Coffee, Crime, and Wine, thanks for being here. And I will see you guys very, very soon. I love you all. Have a great day.